And welcome back. You're still watching The Globe here on SABC News Channel. South Africa's Public Protector Advocate Busisiwe Mkhwebane says she feels vindicated. That's by the Western Cape High Court ruling against the decision to suspend her. The court has declared President Cyril Ramaphosa's suspension of Mkhwebane invalid. But according to Section 172 subsection 2 of the Constitution, an order of constitutional invalidity against the President has no force unless it is confirmed by the Constitutional Court.
This order is effective from today, and which is saying the suspension is invalid. And that's what I would say is a very important issue. Another part of the judgment which the public should read and focus on is paragraph 157 of the judgment, where it found that the President hurried in the nature of the suspension of the applicant in the circumstances, notwithstanding that there was a judgment of the full court that was looming on the same subject, which leads this court to an ineluctable conclusion that the suspension may have been retaliatory and hence unlawful. So it was certainly tainted by bias of a disqualifying kind and perhaps an improper motive. And in our view, the President could not bring an unbiased mind to bear as he was conflicted when he suspended the applicant. So that is very key and critical in this particular matter, because it was based on constitutional principles, but also the principles relating to common law, and it relates to the issue of biasness. So I think that's very critical to take note of. And I think it's very critical as well that the court also indicated that me exercising my right by going to court also, it's not a sign of abusing the court process, but as well it assisted the process.
Meanwhile, the presidency has noted the ruling handed down by the Western Cape High Court.
The presidency has noted the ruling handed down by the Western Cape High Court this afternoon, stating that the president's decision to suspend Advocate Mkhwebane is invalid. The presidency will seek guidance from the Constitution on the next steps.
Let's speak now to legal expert and commentator Reitumetse Benedict Phiri. He shares his observations on the matter. A very good evening to you, and thank you so much for speaking to us, Reitumetse. Perhaps let's just first start with what the legal team of the then suspended public protector, and I'm not sure if then or now is the accurate word, because as we heard there, that according to some detractors, the decision cannot stand until the apex court has ruled on it. What are your thoughts? The suspension was set aside, we understand, because it could be reasonably seen as retaliation for her decision to investigate a complaint against the president flowing from the theft at his game farm.
Yeah, I think, when we look at the judgment, there certainly were two aspects that were raised. One was the constitutionality of the president's suspension. And secondly, a residual principle around the legality of the president's suspension, which does not necessarily speak to the Constitution as such, but to the common law as a whole. The judgment is clear that the suspension is with effect, is set aside with effect from the date of the judgment, which is today. And obviously, there's the question then around the question of the constitutionality of the president's suspension. But if you look at it from a legality perspective and you look at the judgment, certainly my view is the same as the public protector's view, that we don't necessarily need to wait for the ratification of the Constitutional Court in this particular instance, because there was a common law legality challenge that she brought, which the court actually upheld as well.
So there were two matters before the public protector that had to do with President Cyril Ramaphosa, and the timing of which was argued by the public protector and her legal team, the court making a finding saying only on one of them there was common cause, and that had to do with the Palapala game farm. Just expand a little bit more on these findings.
Yeah, and I think that is an important consideration, because in this particular instance, it certainly seems to be that, the Palapala investigation has become the president's Waterloo, because when the matter got heard the first time, or at least part A of the application, which was an urgent application to interdict, the court in that particular instance, which was also 3 judges, found that all these other investigations, Bosasa, all these, I think there were 6 or 7 other investigations that were involved that the public protector was looking at the president on, had no bearing on the president's exercise of his powers under the Constitution. But what happened with respect to Palapala was that the public protector announced, or rather sent questions to the president, and then the following day announced publicly that she had been investigating, and then immediately after that, the next day, the president suspended her. So within that context, the court found that, it had to be that the president literally, approached the matter in a knee-jerk way and could not have brought an unbiased mind to the issue. And what was important was that all that was necessary was a reasonable apprehension of bias. He didn't need to be fully biased. If there was a reasonable apprehension of bias in the same manner that we would apply it to judges, he should have then recused himself and relied on the other provisions of the Constitution to allow either the deputy president or another member of cabinet to make that decision of suspension. Because immediately when there was a reasonable apprehension of bias, it meant that his decision to suspend the public protector could not have been legal, at the very least.
So just, I want you to focus a little bit more on the issue of the recusal of a judge and the same principle being applied, but also the court noting that the ruling handed down the day after Mkhwebane's suspension rejected her submission that a conflict of interest rooted in the fact that her office was investigating various complaints against him disqualified him from exercising his constitutional power in this regard. And I recall that at the time, in defense of the president's action, it was said that he is relying on parliamentary procedure, that it was pretty clear, it was pretty outlined for him what he had to do just in terms of where the process was legally.
Yes, and I think that's correct, because at the time that the court gave the judgment, which basically dismissed the public protector's application at that time, which was a day after the president had suspended her, the Palapala investigation had not formed part of essentially what the court was dealing with in determining bias or a conflict of interest. So the complaints or the allegations or the investigations that the public protector was dealing with respect to the president did not give rise to a conflict of interest according to the court at that particular instance. But this court, which heard Part B of the application, found that the sequence of events, between the public protector sending questions to the president, the public protector publicly announcing that she had been investigating, and the president suspending her, and then following that, the court making the decision a day after, basically pointed to a conclusion in the court's mind that the president actually acted as a result of that investigation commencing. And that had not been ventilated in the first court case, which had dealt with all these other investigations. And certainly, the court said, well, the president could have suspended the public protector the whole time. But the question is, why did he suspend her immediately after getting these questions, and this the public announcement was made by the public protector. And when you look at those two incidents together, on the basis of the fact that the court was going to make a ruling on the ability of the president to make the suspension the following day, you couldn't come to a different conclusion other than that the president acted in a knee-jerk reaction and not necessarily in a rational and considered way. And he rushed this decision based on what was happening around that time. And on that basis, you couldn't say that he applied his mind in an impartial manner. And certainly, in respect of Palapala specifically, there was certainly a reasonable apprehension that the president's private interest, which is him conducting business in a private capacity, would conflict with his role as the president of the country. And definitely for that reason, he shouldn't have been able to make that particular decision. So that is why the court said, in respect of that suspension, which seems to be triggered by Palapala, the president acted unlawfully.
And it was found by the court that the president breached Section 165 of the Constitution. We'll talk a little bit more about that and how she can continue. I understand that the lifting or the invalidating of the suspension is not done retrospectively to allow the deputy that was acting in her position to continue her work. Let's take a listen to the kind of work that she says her tenure has been about.
I would want to assure the people of South Africa and the public and the staff of the Public Protector, by the way, congratulations to them. They've worked so hard. We have the third clean audit. And to the Deputy Public Protector who was holding the fort, that, you know, let's just forget about all these things. I will still continue subjecting myself to this parliamentary process, but let's protect the public. That's what I'm there for. And I think, unfortunately, the DA might have their ulterior motives as well, and the issue of desperation. All right. But then I think I'm saying to DA, let's just focus on the poor, the marginalized, and, you know, ensure the issue of good governance in the country, and make sure that we all ensure that the public is protected from raw state power and the powerful forces. Can South Africans read paragraph 157 of the judgment and 155 of the judgment, where the judgment is very clear that, I mean, the issue of on these objective facts, it is reasonable to form the perception that the suspension of was triggered by the decision of the applicant to institute an investigation against the president. And there was no other plausible or logical explanation for the premature suspension. That's what is in the judgment. That's what we argued. And as well, why rush to suspend when the decision of the court was expected the following day.
All right. Those are just some of the points we've covered as well, Reitumetse. But the Western Cape High Court found that Advocate Mkhwebane failed to satisfy the test to show the timing of the decision to suspend her was designed to frustrate the enforcement of a court order in her favor, and that the president was therefore in contempt of court. Just talk us through this. Effectively, what does it mean?
Yeah, and I think that's an important finding, because one of the arguments that she had advanced, or submissions that she had advanced in the hearing, was that the president's conduct effectively amounted to a constructive contempt of court, which means that you know, you take conduct or make a decision that is intended to frustrate the operation of a court order that you know is imminent or is about to be handed down. So that does amount to a contempt of court, even though there isn't a court order in place at the particular time. So in this particular instance, the president basically argued that, you know, he had been advised that his prospects of success in this matter were quite good, and that he was empowered to make the suspension in any event, and that suspension wasn't designed to frustrate the outcome of that court application, which he eventually won in any event. So the court found that there was no basis to suggest that in suspending the public protector, the president was intending to frustrate the eventual outcome of that court application, which the public protector lost in any event. So in that respect, the court found that it couldn't find that there's a contempt of court or a constructive contempt of court on the part of the president.
All right. Thank you so much, Reitumetse. And that, just to clarify earlier, to correct something that I said, the court also rejected the public protector's twin argument that the president had breached Section 165 of the Constitution by undermining the authority and of the judiciary in order to meet the test here. The court said she needed to prove contempt, and hence this leg of her argument failed to. Thank you so much, legal expert Reitumetse Benedict Phiri, just speaking to us and sharing his views on the outcome of the Western Cape High Court findings on the public protector's court application. Now,